Welcome back to breaking news here on the Law and Crime Network pertaining to the trial of former NFL player Kellen Winslow II. The jury has sent a note to the judge. We have it for you. Here it is. As of 1:55 p.m. on the 10th of this month, the jury has come to a decision on 4 out of 12 counts. That is note number 4 that jurors sent to the judge. In this case, they're clocking in at more than 20 hours of deliberation at this point. Attorney Michel Bryant here with me on the Law and Crime Network. So, Michael, that looks like a statement, not a question to me. So I'm not sure, how does the judge respond to it?
The judge says thanks. I don't know.
Yeah, right.
He's going to have to explore what that means to this jury. Well, how can we help you? And I think he has to be vague about it. He doesn't want to plant seeds suggesting they have maybe deadlocked on the other 8 counts. He wants to just find out what they need.
I tend to agree with that assessment as well. Okay, so what could this mean? This could be a statement. Well, here is where we are in the process. We've been at it for 22 hours. We've got a verdict on 4 out of 12. We need to basically let you know that's where we stand. We're still hashing out the other ones. Or do they mean they're deadlocked on the other ones, and that is what this really means?
Yeah, I mean, it could go either way. I think it's odd that they would just give a progress update. That seems strange to me. It seems more to me that
it's like an elementary school report card.
Yes, needs improvement. Yes, incomplete.
Every 2 weeks.
Yeah. So I'm thinking it's maybe more the former, that hey, we're not making progress on the other 8. But they got to tell the judge that.
Exactly. Okay. So the judge has to maybe sort of ask them what they mean by that and try to figure that out. So another question here, what counts might they have decisions on and which counts might they not?
I mean, it could be across the board anything. Are they counts that apply only to 1 or 2 of the alleged victims? Because each one has at least 2 counts that they're alleging. Some have 3. So is it 1 from column A, 1 from column B, 1 from column C? It could be all over the map. It could be 3 to 1 victim that they don't believe at all.
Yeah, I mean, they've asked for so many readbacks and whatnot and other pieces of information. So I'm wondering if they turn around and they say, we're unanimous on 4 and we're not on the other 12. So what does that mean? Theoretically, the judge could, assuming that they have a dynamite rule in California. They do, okay, because half the states don't. You're licensed there, I think. I'm not. So you would know. Okay. They can send them back and say, then keep working on the rest of these counts here. We also have some of the other jury notes that they've asked about in this proceeding. Let's look at note number 3. This is the one that came late last week. The jurors could benefit from an explanation as to what being under oath means. Additionally, how we should follow the law and not what we think the law should mean. So place your hand on my script.
I swear to tell the truth, the whole truth, and nothing but the truth, etc.
Is that not self-evident?
I don't know. I mean, it's a frightening question. It really is, because if you don't understand that fundamental aspect of the system, how are you getting past that to understand much more complicated rules of law?
We've got some of the other jury notes here. We've got note number 2. I think we can take a look at that one. Again, trying to get inside the mind of some of the jurors here as to what they're thinking, and then hopefully we can try to figure out what they're thinking. Can we please get a read back of Jane Doe number 4 testimony, as well as Nicole Edwards' testimony? Nicole, the friend of Jane Doe number 4, who was with Jane Doe number 4 the night that Doe number 4 said she was attacked at this party back in 2003. And again, Doe number 4, the youngest of the accusers, she said she was 17 when this whole thing happened. Continuing on with that jury note, they're also asking for a little bit more, talking about an exhibit, which really wasn't an exhibit. It was information. We're going to take a look at also jury note number 1. Can we get an aerial terrain map of Exhibit 88? And they don't have that. So they're asking for bits of information back there. They asked for an exhibit that apparently wasn't an exhibit, and then they asked for more information that the prosecution never thought to prepare. So this jury is seeking and trying to figure something out, and if the state didn't prove its case beyond a reasonable doubt, what happens?
Well, then they can't find any guilty verdicts on anything if this jury understands that. They're still hung up on the oath, so I don't know. I was encouraged by the first few questions.
Yeah, they're taking it seriously.
Then it kind of off the rails after that.
Exactly, and I was noting before that I think that there are different handwritings on a couple of these notes, so we've perhaps got a couple of different jurors at play. We have a response from the judge here on this note. We want to take a look at it here. No, you have received all the physical evidence that was received during the trial. The court cannot provide additional evidence. This was a response back to note number 1. Again, the state didn't provide this to you, so the court can't just decide, oh, this will really help them, let's make it up. This goes back to simple trial advocacy. If you're saying that people are jumping over fences and running around, then you need to put a picture up on the screen. It costs no more than 10 cents to use the mapping software that you can get out there for free, Michael, and draw the map and explain to people where everything went, submit it into evidence, make it easy for the jury.
Yeah, and I think this was related to, I believe, the GPS locating of the defendant at Jane Doe 3's property, because remember there was some GPS fitness tracking evidence that put him at that place, and maybe they just wanted a better view to kind of cement in their minds that he was there and when he was there.
Yeah, exactly. I mean, this helps, and they wanted it, but you can come up with pictures to show in court, but unless you go through the formal submission process, they're not in evidence. The jury can't see them.
Of course, and the judge can't sua sponte just say, oh, hey, here's some extra stuff that might help you. That's not his job.
Speaking Latin.
Hey, thank you.
We're going to listen to what happened during the opening statements of this case. Again, the judge is going to come back out and discuss this recent jury note at about 6 o'clock Eastern time. That's back it up 3 hours there for California time. We're going to listen to what happened during openings, though, in the interim. Here's Rachel Stockman.
Kellen Winslow is a man who has been given much, but it was not enough.
In opening statements, prosecutors tried to paint a portrait of defendant Kellen Winslow as a privileged superstar, repeating the theme that his fame and fortune were never enough.
Instead, he took from these women.
Prosecutor Dan Owens gave graphic accounts of Winslow allegedly threatening his victims as he raped them.
As the defendant's attitude changed, he then told her, I'm going to fuck you, and if you say anything, I will kill you.
The state's case rests largely on the words of the accusers. The defense attacked the accusers as opportunistic liars.
Those accusers aren't giving you the whole truth.
The defense said consensual encounters have morphed into rape accusations because of Winslow's stature.
Jane Doe 1 is charged with kidnapping her. She wanted to get into his car, and they have oral sex. Per her original statement, it was not forced. She left that part out of her statement.
Defense attorney Brian Watkins delivered parts of his opening statements with his hands on the shoulders of his client.
When you're in the spotlight, people want things from you.
While the prosecution spoke for about an hour, the defense's opening lasted only 15 minutes. For the Law&Crime Network, I'm Rachel Stockman.
Let's look all the way back to opening statements in this case. Michael Bryant. So sometimes tactics shift a little bit throughout trial, but I think we stayed pretty true to what the prosecution promised during those openings. Do you agree?
I agree, and it was important that they did because you got 5 alleged victims, you got 12 different counts, and it's a mess as it is. So if they had shifted gears and came back with some other order or some other theory, I mean, this jury is having enough trouble. Come on.
We're going to come back and talk a little bit more after the break about exactly what the jury may be thinking, saying that the jury has verdicts on 4 out of the 12 counts here. Which 4 counts could they be? More analysis as we wait for court to reconvene in a moment.